I'm very pleased today to be able to continue a conversation that's been very important to the work of the Center for Ethics and the Rule of Law on interrogation and torture. This topic is of deep and abiding importance to anyone who cares about the rule of law. It was, in a sense, the topic that launched the Center for Ethics and the Rule of Law as we tried to grapple with the U.S. involvement in this program and the implications that it had for the rule of law. CERL is a nonpartisan interdisciplinary institute dedicated to the preservation and promotion of the rule of law in 21st century warfare and national security. We are, in fact, the only center of its kind housed within a law school, and we draw from the study of law, philosophy, and ethics to answer difficult questions that arise in the context of national security and in transnational conflicts. We hold conferences like this. We produce briefing papers and advise policymakers and members of the military on ethics and the rule of law issues that arise in national security. This topic is not only of vital importance, as I mentioned, to the rule of law and to national security, but it is a deeply interdisciplinary topic. What's exciting about our discussion today is that we've been able to assemble a number of individuals from many different disciplines to contribute to a forthcoming volume on the topic of today's conference. So you'll be seeing continuing work from the Center for Ethics and the Rule of Law on this topic. We've had the good fortune to partner with the University of Geneva in this enterprise, as well as the Quattrone Center. And our speaker today will be of critical importance as we move forward in not only bridging the interdisciplinary gaps, but leading the international charge on rule of law issues connected with interrogation. I'd like to thank my co-organizers at the University of Geneva, as well as the Quattrone Center, and in a moment invite one of the co-organizer, Steve Barella, to come up and introduce our speaker. I just want to take a few moments, however, to say why I think the topic of today's conference is of continuing and vital importance to anyone interested in studying the rule of law. It may seem that the topic of torture is passé now. In 2009, the US formally ended its torture program, and President Obama, in a very optimistic note, announced that he, as a candidate, intended to close Guantanamo Bay and had the intention of, as he put it, looking forward, not backwards. That was a kind of idealistic vision, but unfortunately it has not been possible to not look backwards. As they say, the past is present, and this topic has been a continuing sore on the American conscience and has continued to impact many aspects of our national security process, from detainees who remain in Guantanamo and whose trials are deeply complicated and conflicted because much of the information involved in their initial interviews was obtained under torture, and because the US has not fully admitted to the history involved with those detainees. As recent events regarding the nomination of Gina Haspel to direct the CIA also demonstrate, it remains a subject of deep moral controversy in this country and as well as worldwide. There were those who thought that Gina Haspel's involvement with the torture program was a minor blemish on her record. There were those who celebrated her involvement with that program and thought that her willingness to engage with leadership and to follow the program in that regard made her particularly fit for that high office. And there were those who thought that it absolutely disqualified her from being a suitable director of the CIA. This debate played out on the floor of the Senate and in newspapers and media outlets across the country without any moral consensus being reached about the relevance of her involvement in that program to direct the CIA. We now have seen, in addition, that Brett Kavanaugh, who President Trump has nominated for the Supreme Court, himself may have had an involvement in that program as staff secretary to President Bush. The U.S. has not revealed all the documents that would help shed light on his possible involvement in that program, so we don't fully know the facts. But the relevance of his potential involvement in that program has also not been settled and remains a subject of ongoing controversy. President Trump has pledged to bring back torture and has said that he believes it works. Yet there is no consensus in the intelligence community or in public policy across the board, public policy experts and in the public at large, as to whether or not it does work, and there is no particular evidence sustaining the claim that it does work, something that we'll be discussing today. So it's very hard to say that this program can now be closed and that we can move on when it remains a subject of ongoing relevance in myriad public policy contexts. We therefore think it's important to continue this discussion and hope to make some advances both in the moral and practical realms with regard to the program. Let me now turn it over to Steve Barella, who is a researcher from the University of Geneva, who is deeply involved in these topics and who is leading our volume on this topic as well, to introduce Juan Méndez. Thank you very much.
Good afternoon and welcome. For my part, I'd like to say how much of a privilege it is to be here at the University of Pennsylvania, and particularly at the Center of Ethics and the Rule of Law. For many years now, I've had my academic eye on the work at CERL, and I've always found they've had very impressive scholarship looking into innovative and thoughtful ideas. And I think that what we're going to be discussing this evening, Professor Méndez is going to present for us, is precisely fits in with that. Professor Finkelstein has also indicated that we are working on a volume that is meant to, in fact, undergird this universal protocol that Professor Méndez is going to be speaking to us about. And so next year, I do invite you to keep your eye out for a volume under looking into interrogation and torture. It's going to be in the series at Oxford University Press under Ethics, National Security, and the Rule of Law. Now, Professor Méndez, who I have the privilege to introduce this evening, is a professor of human rights law at the American University Washington School of Law. And he's a former special rapporteur on torture and other cruel and inhumane and degrading treatment or punishment. And as you can tell by that mouthful of a title, in fact, those of you who have studied this issue is something that has created many legal problems about the definition of what type of treatment, what type of ill treatment falls into what particular category. Now, Professor Méndez is a native of Argentina, and he has dedicated his legal career to human rights, and his long and distinguished record goes throughout Las Americas, and because of this work, he in fact was detained and tortured and held in administrative detention for over a year. This evening, he's going to speak to us about the Universal Protocol for investigative interviewing. And as was pointed out, this is an idea that is working with new scholarship that's coming out that we're learning about from science and practitioners about what are the most effective interrogation techniques. And with that, I'll let Professor Méndez speak.
I would like to thank Professors Finkelstein and Varela, the University of Geneva, the Quattrone Center, and UPenn Law School for inviting me to speak today. It's a real privilege to be invited to this very prestigious law school. I will speak as a member of a newly launched steering committee for the development of a universal protocol for non-coercive interviewing and procedural safeguards. It is a privilege for me to share with you the vision we have for the development of such a universal protocol, why the protocol is necessary, the vision we have for the document upon its completion, and the progress we have made to date. In my last thematic report to the General Assembly in October of 2016, I called for the development of a universal protocol to ensure that as a matter of law and policy, no person, be it a suspect, a victim, or a witness, is subjected to torture, ill treatment, or coercion while being questioned by law enforcement officials, intelligence personnel, or other authorities with investigative mandates. Around the same time, the Human Rights Council adopted Resolution 31/31, calling for the implementation of safeguards to prevent torture during police custody and pretrial detention. Subsequent to the release of my report and the adoption of the resolution, development of the protocol has been recognized as a critical objective by numerous stakeholders and has received broad support from civil society, law enforcement professionals, academics, psychologists, international organizations, and member states of the United Nations. As we work to develop a protocol, continued support from the international community and organizations and individuals such as those present here will be crucial to realizing the successful drafting, adoption, and implementation of guidelines set forth in the protocol. In doing so, we will move one step closer to reducing the incidence of torture and ill treatment around the world and strengthening the protections for persons interviewed by authorities who, as a result, find themselves confronted with the entire repressive machinery of society. End of quote. Law enforcement officials and other investigative bodies play a vital role in serving communities, preventing crime, and protecting human rights. One of law enforcement's key competencies is the conduct of interviews. The information derived from these interviews plays an integral role in the criminal justice process, affecting the outcome, reliability, and fairness of criminal proceedings. However, questioning, in particular of suspects, is inherently associated with risk of intimidation, coercion, and mistreatment. Every day, societies are repeatedly confronted with the reality that torture persists, particularly in the context of law enforcement interviews and during the first hours of custody, despite its absolute prohibition under international law. This risk is heightened for vulnerable populations. The manner in which law enforcement officials and other investigative bodies carry out interviews is of significant importance and must reflect fundamental principles, such as the absolute prohibition of torture and ill treatment under international law and core human rights standards, including the interviewee's right to dignity and physical and mental integrity. At the same time, although international law mandates that due process guarantees and safeguards, including the right of access to counsel and the right to remain silent, be afforded during questioning in order to counter the risk of torture and ill treatment, such safeguards are often absent or denied. The absence of basic legal safeguards nourishes an environment where coercive methods of questioning are encouraged. Although procedural safeguards are enshrined in international law and in conventions, they are often not part of states' domestic legal systems, and when they are rarely implemented on the ground. Justified by the need to fight crime and counter terrorism, abusive interrogation practices risk becoming normalized and widespread. In many parts of the world today, a suspect's confession is still considered the strongest form of evidence, often leading to incrimination without the inclusion of corroborating evidence. This phenomenon is one of the main incentives for law enforcement officials' continued use of physical and psychological ill treatment. the pervasive sense that confessions establish criminal responsibility beyond doubt, and the inaccurate and invalid assumption that duress, intimidation, and force are needed to obtain a confession are what make the first hours of arrest the most precarious. This is especially prevalent in cases related to state security or to organized crime. Numerous studies have concluded that subjecting individuals to torture or other ill treatment to elicit information is unreliable and a waste of valuable resources, and that it has a long-term negative effect on a society's trust towards its government and law enforcement officials. Further, it has been scientifically proven that torture and ill treatment harm the specific areas of the brain responsible for general cognitive function and retrieving memory. Science has also proven that victims, suspects, and witnesses, if tortured, will say anything to satisfy their abusers and stop the pain. Using forceful and intimidatory interview methods that amount to torture or ill treatment confuses and disorients persons being questioned, to the point where they may actually believe or remember occurrences that have not taken place, leading to inaccurate and deceptive information. In that fashion, justice systems are weakened because justice is not served. Empirical evidence also shows that torture and mistreatment can breed extremism among criminal elements and ultimately more crime. The guidelines that we're working on will therefore be based on decades of rigorous scientific research and evidence that unequivocally demonstrate that torture and coercion not only do not work, but in fact have the opposite effect, as they can produce false and unreliable information. As mentioned, the Universal Protocol will address the time during which the risk for torture and ill treatment is the greatest, that is, the first few hours of custody. In this regard, it is imperative that the protocol operationalize the core principle of the presumption of innocence. Investigative methods around the world today involve questioning individuals as though they are guilty until proven innocent, and not the other way around. These accusatorial methods are beset by psychological manipulation, threats, and coercion. The Universal Protocol will embrace the idea that non-coercive interviewing methods are in fact more effective in fighting crime, in addition to there being the first and foremost legal safeguard. The protocol will also list and develop the basic procedural safeguards pertaining to questioning already enshrined in international human rights law. Moreover, the protocol's universal applicability will be designed to be implemented not only in interviews conducted by law enforcement officials and criminal investigators, but also by military and intelligence personnel and other bodies with investigative mandates. As the prohibition of torture and ill treatment applies to all persons being questioned, the protocol will apply to questioning of suspects, but also victims and witnesses. Further, the protocol will reflect the reality that at times investigations take place outside detention facilities and where suspects are not deprived of their liberty. Scenarios such as these will be important to consider in order to provide additional preventive measures against methods of coercion and ill treatment that lead to forced confessions. The ultimate goal of the Universal Protocol is to prevent torture and other ill treatment practices by outlining interviewing principles and providing a model that respects its absolute prohibition. Application of the Universal Protocol will help states comply with their international obligations, particularly under Article 11 of the United Nations Convention Against Torture, which provides that state parties must regularly review their interrogation rules, instructions, methods, and practices, as well as arrangements for the custody and treatment of persons subjected to any form of arrest, detention, or imprisonment in any territory under its jurisdiction, with a view to preventing torture. Law enforcement officers frequently work in difficult environments and are often not adequately trained to properly respond to the situations encountered, leading them to resort to torture or other coercive practices during interviews and investigations. In that connection, the guidelines will serve as an essential tool for providing much-needed practical guidance to practitioners and to changing practices and mindsets on the ground. The purpose of an interview is to gather accurate and reliable information to discover the truth of the matter under investigation. While accusatory and confession-driven models of questioning are characterized by a presumption of guilt, the Universal Protocol will present a model that is based on the presumption of innocence and pursuit of truth. It will outline a set of guidelines encompassing a human rights-based approach to interviewing that will ensure that interviews conducted by law enforcement, intelligence, and military personnel are carried out with the highest levels of professionalism and will enhance the effectiveness of the justice systems, thus fostering society's trust in public institutions. Undergirding the model is the notion that individuals should not be forced to testify against themselves or to confess guilt as a result of threats, coercion, intimidation, torture, or ill-treatment. Giving less weight to confessions and eliminating the use of coercive investigative techniques will lead to fewer incidences of torture and ill-treatment. The model will comprise a number of essential elements that are vital to prevent torture and ill-treatment. First, it is important that interviewers fully comprehend the primary aim of the interview, to gather reliable and precise information to be used to investigate the matter. It is not to extract confessions or information that confirm the interviewer's preconceptions. Additionally, interviewers must thoroughly prepare for the interview by gathering and studying all of the information and evidence available and know what open-ended questions they will ask. Open-ended questions allow the interviewee to provide his or her own account of the events under investigation. At all times, interviewers must maintain a professional and fair attitude and should build and maintain a rapport with the interviewee. Investigators build rapport by actively listening to interviewees' responses to their questions and accounting of the events. Building rapport is essential to a successful interview, as it can help reduce interviewees' anxiety, stress, and anger, leading to obtaining more comprehensive and truthful information. While maintaining respect for the interviewee, interviewers should nevertheless always analyze the interviewee's answers, weighing the responses against information and evidence already available. Upon the interview's conclusion, an evaluation should be conducted with a view to understanding what could be learned from the process and how the next interview could be improved. Successful interviewers are objective, impartial, and fair, and these three traits are vital in any non-coercive interviewing model. Interviews that follow these elements are far more effective and compliant with human rights standards. It must also be noted that the length of interviews should be carefully monitored. They should not extend for prolonged periods without breaks or rest, as that alone amounts to ill treatment. Long interviews can make the interviewee tired and confused, affecting their decision-making processes, leading them to admit and say anything to make the interview stop. It is also important to note that because of their unique needs, special attention and specific techniques must be used when interviewing vulnerable persons, such as children, persons who do not speak the same language as the interviewer, and persons with intellectual and psychological and psychosocial disabilities. It is promising that a number of states have already moved away from coercive and accusatorial interviewing models and have implemented a model similar to the one envisioned. Successful models, such as the peace model from England and Wales, adopted in 1992, and the creative model from Norway, highlight how planning and preparation, engagement and explanation, accounting, closure, evaluation, and how to strategically use evidence illustrate the critical traits that an interviewer must possess. Foremost among them is the ability to develop rapport with the interviewee. The protocol will underscore these best practices and how lessons learned can be utilized to ensure the protocol's effective implementation. The objective is for the interviewing techniques set forth in the protocol to be enshrined in states' domestic policies and legislation, regardless of the situation in which the state is in, be it an armed conflict or any other emergency. This fair investigating process is the beginning and essence of the fair trial process to which all individuals have a right. The document that we envision will set off a set of legal and procedural safeguards in addition to describing the model of non-coercive interviewing that I just mentioned. The following are some of the main procedural safeguards pertaining to detention that the Universal Protocol will elaborate on. I hasten to add, of course, that these basic safeguards are also part of a state's international obligations because they are already part of the international law of human rights. In general, as soon as persons are apprehended, the detention should be immediately documented in a public centralized detention register. The chain of custody of each detainee should also be properly documented. Additionally, individuals detained on criminal charges should not be held in the same facilities as those controlled by their interviewers. They should be brought promptly before a judge for a hearing that in no case should take place beyond 24 or 48 hours after arrest. Otherwise, the risk of torture, ill treatment, and intimidation is heightened. Further, to ensure that detention or detention conditions are not utilized to coerce an individual into cooperating, the bodies in charge of managing the detention center should be different from those that conduct questioning. Lastly, questioning of suspects in secret or unofficial detention facilities is strictly prohibited. No exceptions under any circumstance. The person arrested should be informed of his or her rights, and they should only be questioned after they have freely and voluntarily provided their informed consent. This means also information not only about the right to remain silent or to be advised by an attorney of their own choosing, but also they need to know what the consequences are of proceeding to the interview with or without exercising those rights. Access to counsel is, in my mind, one of the foremost procedural safeguards in the prevention of torture and ill treatment. Unfortunately, in many countries, access to counsel happens only after the person has spent a few hours in custody and sometimes days. Conducting any interview without the presence of counsel must be strictly prohibited, with a very few and limited exceptions in which a waiver can be understood to have taken place. The presence of a lawyer not only deters officials from using coercive methods, but protects officials conducting the interview from false allegations of torture. Ideally, this right should be available at the very outset of apprehension and, most importantly, before the occurrence of any questioning and any judicial proceeding. In addition, lawyers should have timely access to all needed information of the suspect's case in order to provide sound legal advice. Importantly, access to counsel should be enjoyed by anyone deprived of their liberty regardless of their offense, that is, a felony or misdemeanor, and their status, individuals charged with ordinary crimes and those related to armed conflict, prisoners of war, administrative detainees, etc. The right to remain silent is another procedural safeguard that is integral to the presumption of innocence and central to the prohibition of torture. As with other safeguards, it is enshrined in Article 14 of the International Covenant on Civil and Political Rights, as well as in the Rome Statute for an International Criminal Court and other instruments. We expect that the protocol will also have specific safeguards for vulnerable populations, including children, women, persons with disabilities, minorities, migrants, regardless of status, asylum seekers, refugees, and stateless persons. They have unique needs, and it is important that the protocol carefully outline distinct procedures for members of these vulnerable populations when subjected to questioning, so they can effectively enjoy the rights that I have mentioned. For example, when it comes to the right to information, persons with intellectual or psychosocial disabilities should be given information in a way that is appropriate to them and include the presence of legal counsel or a family member or a guardian. All interviews should be recorded. States should use video and audio recordings of all interviews and in their entirety. This right must be enjoyed by all persons, not just those charged with a crime. Recording impedes coercive investigative techniques, while at the same time provides truthful testimonies and complete records of the interview. The recording must capture the entire room of the interview and show all persons involved. Should also take note of when the interview is interrupted for any reason. Medical examination is, of course, essential as well. Individuals should be provided access to medical care at the time of the arrest and at regular intervals thereafter. Medical examination should also be provided to detainees upon each transfer from one detention center to another. States are obliged to offer prompt consensual medical examinations carried out by independent and impartial health professionals. The examination should be carried out in accordance with the Manual on Effective Investigation and Documentation of Torture, the so-called Istanbul Protocol, in order to properly document allegations of torture or ill treatment. In terms of accountability and remedies for violations of these standards, we expect also the protocol to include references to complaint mechanisms, investigations, and sanctions for violating any of these standards. We also think the protocol should develop the principle of the exclusionary rule, that is, the exclusion of evidence that international law requires to be excluded from evidence from proceedings against a person if the evidence has been obtained through torture or ill treatment. In many jurisdictions, unfortunately, coerced confessions are regularly admitted into evidence, particularly in jurisdictions where confessions are relied upon by law enforcement officers as a primary and at times only means of solving cases, and where the judicial system turns a blind eye to these practices. Therefore, it is vital that the protocol emphasize that the exclusion of evidence obtained under torture is a non-derogable norm in international law. A change of mindset and a move away from the culture of dependence on confessions is one of the foremost aims of the Universal Protocol. The protocol, of course, will prove its worth when it's implemented, and in order to be implemented in the domestic jurisdictions, it's very necessary to have appropriate training and capacity building. In that sense, we hope that the protocol will at least be the basis for useful training manuals in many jurisdictions. In terms of the current state of the initiative, the Anti-Torture Initiative, which is the project in the Washington College of Law that I direct, the Association for the Prevention of Torture, based in Geneva, and the Norwegian Center for Human Rights have joined forces as institutional partners in an effort to promote the development of the Universal Protocol. Building on the consensus gained during a January 2017 strategy meeting hosted by the APT in Geneva, and a May 2017 meeting of technical experts in New York co-hosted by the Office of the High Commissioner for Human Rights, a decision was made to move forward with an expert-driven drafting process. Experts met again to discuss and cement the process during high-level side events during the General Assembly's Ministerial Week in September of 2017, which featured the participation of the Danish Foreign Minister. Following preparatory work in early 2018, the coordination group consisting of the ATI, APT, and Norwegian Center constituted a steering committee comprised of 15 technical experts tasked with overseeing the development of the guidelines. The steering committee features wide geographic and gender diversity, and its members bring technical expertise in diverse substantive areas relevant to the process, ranging from practical expertise in policing, law enforcement, and intelligence gathering to psychology, law, and human rights protection. During its first in-person meeting in Rio de Janeiro in May of this year, the steering committee adopted a tentative plan of work and timeline for the project, drew up parameters relevant to the scope and substances of the guidelines, and agreed to constitute an 11-member drafting group comprised of 2 sub-working groups on the topics of investigating, interview, and on the legal principles and safeguards, respectively. An advisory council comprising a wide array of experts from around the world has also been set up to accompany and provide assistance to the steering committee and its strategic decisions, and to provide ad hoc support as required down the line. For the remainder of 2018, 2 main events are yet to take place. On September 26 and 27, just a few days from now, in Geneva, the drafting group will hold its first workshop to achieve consensus on questions of substance and division of labor, and to commence expanding the outline. In addition, between December 10 and 11, the steering committee will hold its second meeting in Tunis to review the expanded outline, collect and compile feedback and instructions for drafters, and continue strategy and advocacy discussions. Advocacy is needed to secure support for the protocol so that by the time it is published, states are ready to endorse and adopt it. Advocating and promoting for the protocol will be a collective effort from all relevant stakeholders and parties, including civil society, academia, and professional organizations, and hopefully a strong showing by representatives of states of the international community. In conclusion, let me say that a torture-free society is one where citizens trust their institutions, law enforcement officials, prosecutors, and the judiciary system. It is one where citizens have full confidence that these institutions exist to protect them. The Universal Protocol aims to implement the prohibition and prevention of torture and ill treatment by mainstreaming non-coercive questioning techniques and insisting on the importance of safeguards in the fight against torture and other forms of ill treatment. It will be an important tool to change mindsets and the institutional culture that relies excessively in obtaining confessions as the chief way to solve crimes, particularly after showcasing how coercive methods are ineffective and lead to unreliable information, which undermines justice systems and erodes society's trust in institutions. Once finalized, the protocol will contain a set of non-binding but highly authoritative guidelines on the conduct of non-coercive interviews and the implementation of safeguards, intended to assist law enforcement officials and relevant authorities to achieve better operational results while protecting human rights and meeting the obligations to prohibit and prevent torture and ill treatment. Grounded in scientific research and empirical evidence that demonstrate that intimidation, ill treatment, and torture do not work, the Universal Protocol brings that understanding to a universal level. It moves us one step further away from confession-driven criminal justice systems and one step closer to making the absolute prohibition of torture a reality. We hope to count on your support for this effort. Thank you very much.
I'd like to ask the members of our distinguished panel to come up now. We're going to have a generalized discussion about Professor Méndez's remarks, and then we'll open up for audience conversation. Thank you so much for those, for the very important project that you're engaged in, as well as your description of it here today. I'd like to begin by asking you to reflect a little bit more personally about how you came to this topic and what your experiences were in Argentina in the 1970s that led you to take the interest in torture that you did.
Well, thank you. Well, first, let me say that I want to recognize the support, the very enthusiastic and essential support that I've received when I launched this idea 2 years ago by many people, but especially by two or three of you who are here tonight, Mark Fallon, Steve Kleinman, and I'm hoping that I don't forget anybody. But it means a lot to me that you, with your experiences, and so many other people have thought that this is a worthwhile endeavor. And I am very enthusiastic about how we are progressing on that. In terms of your question, Professor Finkelstein, I was a young lawyer in Argentina in very difficult, very hectic times. I had already, as a law student, started being a political activist. I practiced for about 5 years or so, and I was twice arrested. The first time I was not tortured, but I was, there was an attempt to frame me for gun possession, which was as I said, a frame, and the judge dropped all charges and released me within about 3 days. But the second time, this is 1975 already, the state of siege was in effect. And I was arrested, and I had to move from my hometown to Buenos Aires. And in the suburb of Buenos Aires, I was arrested. That time they did torture me, and very severely. Like many other people arrested, well, both for common crime offenders, but also suspected of subversive activities, quote unquote, the main system of, main method of torture was the electric prod. And I was subjected to it in 5 sessions in less than 24 hours, which was in a way worse than for most people at that time, because generally they would do 2 sessions a day for like 7 or 8 days. But in my case, the fortunate thing was that my family was so involved in trying to locate my fate and whereabouts that my interrogators were very much in a hurry to get as much intelligence from me as possible. So that's why they did it more intensely, but a much shorter period. After a few days, I was taken to a judge, and the judge, a medical doctor from the police actually was, from the courts, was actually able to document that I had been indeed tortured. And so the charges were dropped, and I was not accused of any crime, but I remained in custody for 18 months in administrative detention without charges for about 18 months, as I said, pursuant to the state of siege or state of emergency that was in effect already then. Through the international solidarity of an American family that had hosted me as a foreign exchange student, I was adopted as a prisoner of conscience by Amnesty International, and many members of Congress from both, and senators from both sides of the aisle, wrote letters on my behalf, and that also shortened my stay in prison. I mean, for people in my exact same legal situation, or illegal, the par for the course was 4 or 5 years at least in custody. Some of my friends spent up to 8 years, and I was able to not be released, because they didn't release me. They literally escorted me to a plane and expelled me from my own country in 1977. And I came to the U.S. and reunited with my family, and I started working on human rights that long ago.
Would you mind, just before we start our panel discussion, saying a few words about the impact of torture on you, what the experience was, the aftermath of the experience?
No, it's difficult for me to say, beyond what you expect, the nightmares, the fear of being tortured again, the difficult relations with my young family when I was able to see them, when they visited me or when we started our life again. But I've been very fortunate because with their support and with the support of so many other people in this country and elsewhere, I was able to become a lawyer again in this country and to dedicate my career to the pursuit of enforcement of human rights. After that, I've interviewed many people who have been tortured, not only as a special rapporteur on torture, but even previously when I worked for Human Rights Watch and also for the Inter-American Commission on Human Rights. So I have been around this issue for a very, very long time. So I think the impact is generally positive, but it hasn't been without some having to reckon with the legacy of torture and finding in it a motive and a motivation to work on behalf of other torture victims.
Let me now formally introduce our other interlocutors. Here are Alberto Mora is the current director of the American Bar Association's Rule of Law Initiative. He's also a fellow at Harvard's Carr Center and was previously the general counsel of the Navy. I'm proud to say he's also a CERL board member. And to his right is Dr. Steve Xenakis, who is a retired Army Brigadier General and a psychiatrist. He works extensively with Guantanamo detainee defense teams and is an expert in PTSD, among other things. He's also a CERL board member. So I'd like to open up discussion now a little bit. Steve, could you tell us a little bit about what you find when you talk to those who have been tortured, what the typical psychological effects are that you encounter, and how widespread it's been in your experience?
Well, sure. I first want to express my deep respect for Mr. Méndez, Juan, for what we heard today and for his work over the years that our paths have crossed, for his thoughtfulness, for his commitment to what he's doing, for the leadership in his character that I think has had a profound effect. I have been around a number of locations our paths have crossed of different men and women who have one way or another been caught up in this web of being of arrest and then subsequently subjected to these brutal treatments and handling. One observation has been that there is a playbook that is commonly used, and I've seen it in a number of different countries. And to my dismay, I've seen that our own forces have sometimes used the same tactics in various situations. So there's a common practice here, and the victims, the subjects themselves very often have a similar report of how it's affected them. I mean, they're shocked. Interestingly, in some countries, they're not the first family member who has been picked up, so it's not uncommon in their communities. They sort of expect it. They've been caught once or twice themselves, so they develop protective mechanisms. I think that has all sorts of, as we call them, strategic implications. I mean, it's very disruptive, but it is part of the human condition. I mean, they have nightmares. They're irritable. They have all the various signs and indications that we call PTSD. And there are those who are more resilient and are able to manage their interrogators in ways. I mean, they're very capable folks. But even they, one way or another, really have, unfortunately, will carry with them indelible, harm and injury from this.
Alberto, can you tell us a little bit about the broader impact of the U.S. torture program under the Bush administration and what you feel the impact has been on the rule of law as well as on our national security practices and effectiveness?
That's a critical question in discussing this topic. As so often, the American public and American leadership has framed the issue of torture as whether it works to make us safer or not in the war on terror. And the defense of the torture program was that in fact it did work, that it made us safer as a result of the CIA and the military's utilization of torture as a weapon of war.
I just want to make sure everyone can hear him. Can you hear? Can we turn his? Are you muted? Let's see.
It's on.
It's on.
We probably just need to turn it up a little bit. If we can.
There's a mute button too.
Is it
No, I
green
think
or
it's
is
on.
it red?
No, you're on. No, you're on.
He's on. He's just got a quiet voice.
Yeah.
If we could
Yeah,
just
got a
turn
quiet
his
voice.
microphone up a little bit. That would be helpful.
So let me try again. Let me speak a little bit louder. So the debate, such as it has been in the United States, has framed the issue as whether or not torture worked. The architects and defenders of the torture program in the Bush administration and then the successor administrations that supported the program, not the Obama, but we'll touch about it in a second, always framed the defense as it was legal, necessary, and effective. Effective from the context of protecting the nation. But really, the issue about whether torture works or not begs the question, worked as measured by what kind of standard? And typically the defense has been, did it work in the interrogation booth or dungeon? Was it effective in eliciting important information that contributed to some military operation or intelligence operation that helped thwart an attack or advance the military? But the reality, as the question implies, is that you can't look at torture in isolation of the totality of its consequences. And the truth is that when the United States decided to use enhanced interrogation, meaning torture, it necessarily altered our structure of rights, particularly the right that has been seen to be as one of the foundational rights of the American nation, which was the right to be free from cruelty, as evidenced in the Eighth Amendment and the jurisprudence of the Fifth and 14th Amendment in the Supreme Court. Also, this is a basic right in the architecture of human rights globally and in the structure of international law that protects individual human beings. So what the United States did necessarily by adopting, even for a few people, the enhanced interrogation techniques, was to take the right to be free from cruelty out of that basket of protected, inalienable rights and say, no, it's back in the state. It's a matter of every state, including the United States, to decide whether or not to use torture as a weapon of war or a national security tool. This had enormous consequences, negative consequences in the battlefield and in our foreign relations and national security strategy. In the battlefield, and there's a lot of evidence about this, the use of torture in Iraq and Afghanistan actually had negative operational consequences. The use of torture was understood by local populations, not only the enemy, and then it increased suspicion, hostility against American troops, and led to a decreased cooperation that had negative consequences in the war.
So let me slow you down there just a little bit so we can catch up with you. So you're saying it actually put American troops at greater risk because of the level of hostility to the U.S. and to U.S. forces because of the program?
There's no question about this. In fact, one can refer to a U.S. State Department cable, 2006, out of Embassy Kuwait, that is found in the WikiLeaks collection of diplomatic cables. And the group that was assembled there, which included representatives both in theater and from Washington, out of state, National Security Council, CIA, DOD, General McChrystal was a senior military officer present during the entire three-day conference on this. And the theme of the conference was to determine how to establish a better strategy to fight the war against terror in Iraq. And the primary conclusion of the group's finding was that the primary cause driving foreign fighter inflows into Iraq into combat against American forces was the use of brutality by the United States in detention facilities. Abu Ghraib, Guantanamo, and theater in Iraq and Afghanistan. It led to perhaps over 80% of the foreign fighters that came into the theater was the primary motivating factor for them to come into theater. Those individuals killed Americans frequently into theater. And so the Joint Military Intelligence Group there had come to the conclusion that one way to improve the combat effectiveness of American forces was to eliminate the abuse of prisoners in detention by American forces, and thus to lessen the pressure that contributed to foreign fighters coming into the battlefield. But just very briefly, the American use of torture also fractured our strategic alliances with our traditional European allies. New Zealand, Canada, UK, the rest of Europe, they were determined not to follow the United States into the swamp of torture, and devised mechanisms to distance themselves from American military intelligence operations, which could use torture as an element of its operations. So there are really multiple ways in which the use of torture had broader strategic consequences that damaged the United States. Net, I think the data shows, and the argument can clearly be made, that the damage to the United States security from American use of torture clearly outweighed whatever questionable benefits some argued we obtained at the tactical level.
President Trump has argued, as I mentioned in my opening remarks, that torture works, that we should bring it back, and he has, of course, now appointed Gina Haspel to direct the CIA, and she's been confirmed. What is the reason for thinking that torture may have generated actionable intelligence, if there is any, and does this rely on a mistaken premise in your view? Just ask you to expand on that a little.
I think probably the primary evidence for this is to be found in the Senate Select Intelligence Committee torture report in 2004.
14.
The Senate,
2014.
14, sorry, yeah, exactly, 2014. The Senate came to 20 conclusions about the effectiveness of the Senate torture program, and all the conclusions were negative. In fact, they concluded that there's no evidence to be found in the CIA's own documentation of effectiveness in the enhanced interrogation program, which they conducted. That finding, by the way, parallels a Senate Armed Services Committee finding conducted in the course of its investigation of U.S. detention and interrogation policies, that the use of enhanced interrogation weakened the United States and made us less safe in the war against torture. So I think the evidence is in. Now, some of the architects of the torture program claimed it had some effectiveness, but I think the weight of the evidence argues the contrary.
You spoke, Juan Méndez, about the importance of using rapport-building techniques and to protect that in the Universal Protocol to ensure that interrogation follows those lines rather than using force to try to elicit confessions. Why is there emerging evidence that rapport-building techniques would be more effective in conducting interrogations than using torture or other brutal means?
Well, first, obviously, using any kind of brutality and even any kind of coercion is contrary to domestic and international law. And so in pressing hard for countries to abandon torture as a means of interrogation, we found ourselves that we needed also to provide alternatives to show that, in fact, there are better ways of solving crime and of protecting citizens. And I found after convening a meeting, a consultation of experts, and before I wrote my last report to the General Assembly, I found out that, in fact, there are models. There are countries that have adopted a very comprehensive way of conducting interviews while complying with the objective of the pursuit of truth, the implementation of the presumption of innocence, the absolute prohibition of any form of coercion that are all part of their state's obligations. It almost seems that it's not a coincidence that those countries also have a relatively low incidence of criminal activity. So yeah, some people would say, well, they can have the luxury of not torturing because they have low criminal activity, but I actually think that it's the other way around. They are much more effective. They know how to deal with crime, and they protect their citizens and their own law enforcement people. For example, if you were conducting an arrest in a favela in Rio de Janeiro, more than likely you as a police officer would be attacked because the persons that you're going to arrest know that they're going to be tortured. And they are more likely to resist arrest rather than be subjected to torture sometimes again and again. And so it even makes sense for, from a perspective of the institution's own effectiveness in operations and its enjoyment of trust and confidence by the population that ensures that they will get cooperation in solving crime, not to torture rather than to torture. I have to add that although the model is officially in place in some highly developed countries, you talk to police officers in many countries, even very poor countries, and they all understand why this is a better model. They do understand. Obviously, I haven't talked to all of them, and I'm sure there are some that would rather remain in this culture of brutality. But people who know what they're talking about, people who have had to investigate, people who train police academies, for example, are joining our efforts towards this protocol because they know that it could be a much better way for all societies, not only highly developed societies, to protect their own citizens and to solve crime.
One of the interesting but potentially controversial aspects of the Universal Protocol you are proposing is that it cuts across contexts. So we're not actually used to thinking about interrogation in a local criminal context in the same breath with interrogation in a national security context. That could be, I imagine, controversial because people may say these are very different contexts. What is the argument for putting these in the same baskets, and why should we not think of the context as dramatically different, both legally and in terms of efficacy?
Well, I mean, like you, I've been living in this country for many, many years, and I had never thought that we would see a day in which a government official of the United States would torture a suspect. And yet it happened. And it happened officially, and it happened maybe limited to the so-called global war on terror, but it happened, and it has not been properly investigated or prosecuted as it should have been. What I can say is that from my experience, in dictatorships in Latin America, the argument was made that these societies were besieged by terrorism and by subversion and insurgencies, etc. And in some cases, this idea was, of course, not fanciful. It was true. There was a lot of political violence. But sooner or later, the methods spread also to the pursuit of common crime as well. And so now, you know, in my own country, we have 35 years of democracy, and even today we have not been able, there's no violence, no political violence of any sort, and we haven't been able to eradicate torture in the investigation of common crime. And of course, it means that, you know, the suspect of corruption or the white-collar crime offender, they are not tortured. But the poor, the young, the unemployed, those are tortured very frequently in order to obtain confessions and solve the case. And so the lesson that I think can be learned is that once you allow a little window for torture, even if it's for the most extreme cases and isolated from all other criminal justice systems, you vitiate and you poison the whole institutional setup. And I hope we haven't got that far in the United States, but now that police bodies around the country are heavily militarized, they buy all kinds of weaponry that the Pentagon has to discard, I think there is a relationship between the tolerance that we have shown for torture in the global war on terror with the lack of investigation of the Black Lives Matter incidents. So it's obviously the use of torture, the pervasive use of torture, but more significantly, the impunity for the use of torture that can have very negative effects towards the whole credibility and legitimacy of the system itself.
So Alberto made the argument rather forcefully that the use of torture with regard to detainees from Iraq and Afghanistan actually made us less safe and set our national security goals back. Would you say that there is evidence of the same thing in policing, that the use of brutality in interrogations and of obtaining forced confessions and so on actually makes a country or a state that employs these methods less safe?
Well, I want to make it clear, I haven't seen evidence of use of torture by police bodies in the investigation of common crime in the United States so far. I was talking only about
Though we do know that such incidents have occurred.
Yeah, they have occurred and they haven't been properly investigated. Right. But it mostly have to do with, brutality in the arrest or arrest without credible, probable cause for arresting, etc. That the victims always seem to be coming from minorities or from impoverished parts of society. What I'm saying, however, is that the fact that we have been tolerant of the torture that happened during the global war on terror, and I have to say that it's important to note that after 2009 we don't see new cases. So I'm not going to stick my reputation in saying that torture doesn't happen again, because it's so clandestine that who knows. But it's significant, I think, that after the executive order by President Obama, we don't have new cases of extraordinary renditions, of torture, etc. I think a lot has to do with Alberto's argument that many countries have been burned by this and don't want to help the United States anymore. Fortunately, that is also why we don't see a resurgence of torture despite the promises of President Trump during the campaign. But what I am saying is that the United States, the prohibition on torture and the return to the Uniform Code of Military Justice was very welcome, and it has had some important effects. And the Senate Select Committee on Intelligence report, and previously the Senate Committee on the Armed Forces reports, were very important in complying with at least one obligation of the United States, to tell the truth about at least partial compliance with it. But that's not enough. It's not enough to prohibit torture. It's not enough even to tell the truth. The international law obligation is to investigate, prosecute, and punish every single act of torture. And that has not happened. And because it hasn't happened, torture can happen again. And it can spread. It can spread to local law enforcement bodies. It can spread to prosecutors and judges around the country turning a blind eye to torture, etc. I'm not saying it's already happening, but I am raising the spectrum of maybe it will happen, and that's why we need to insist on what the U.S. obligations are.
Good. I do want to go to the issue of accountability, but just before we do, Steve, I wanted to ask you, to tell us a little bit about the impact on the interrogator. What is the concept of moral injury, and why is it used sometimes in connection with the impact on the interrogator in using brutal methods of interrogation?
So there have been several of these interrogators, soldiers that I've interviewed and worked with, who find themselves years after they've been involved in these activities, just very dismayed and distressed as they look back on what they've done. And they are, of course, now they've aged. They have relationships. Their life has a different quality, lifestyle, and they look back and wonder and question themselves very deeply of did they do the right thing. In their minds, it's not quite PTSD because they are not directly linking it to some event that really frightened them at the time, but they were aware that they were frightened or that they felt that their life was in danger, the kinds of things that we talk about when we say that someone's been traumatized. It's really an acknowledgement of what they did and the guilt in many ways that comes with it. So you have a number of people that will visibly feel that, and it'll affect their lives. I think there are a number of people, as you know, all of us, as we've gone through our military careers, really look back and say, "What was really that the right thing that I did?"
Why would people be traumatized by something that they had control over, something that they chose to do, and where presumably at the time they had a kind of commitment to it or a moral alignment with it? Why would that leave a scar?
Well, one, because there's any number of situations that we're in that we don't have as much control as we think we do. We're not the agents of what we do in the way that we may have imagined or hoped that we were at that time. And there's, a lot of pressure. It's a very tense situation. You've got people on top of you telling you that this is what you've got to do. You're in a situation that you may or may not, you probably won't challenge them. And so you can justify it. You can rationalize it. And then you're out of that situation, and you now are able to rethink it, you sort of recycle it again, and you say, well, wait a minute. Maybe I should have been more of should have exercised more agency than I did. And ultimately, part of being a soldier is you're trained and you're expected that you're always going to be the agent on the front line doing what you think is the right thing, and with an expectation that if you get an order that you don't like, that you're going to disagree with it, which is probably not as solid as we would like to think.
So let's talk now about the topic of accountability. At least with regard to the US program, there have been no prosecutions of any of the authors and architects of the torture program. There have been some prosecutions of some individuals who carried out the program, who were fairly low down in the chain. And then, as we know, Gina Haspel was, of course, elevated to director of the CIA and, in effect, rewarded for her involvement in the program. Is it important, Alberto, that there be the kind of legal accountability that you might see with prosecutions? And if no such accountability occurs, what is the effect?
Law without accountability is an empty vessel. By definition, if you criminalize activity or prohibit an activity but don't hold people accountable, then it eliminates the effect of the law and essentially neutralizes it. The problem with lack of accountability has several dimensions. First of all is that we tend to blur the definition of torture. by not holding people accountable, we tend to reinforce the notion that, well, perhaps what we did was not torture, that it was some lesser form of harsh treatment that might be regrettable in some respects, but never tripped the legal tripwire. And if that's the case, then we just don't exercise a prohibition against cruelty that's so necessary as a component of our law. Also, we lose our moral authority. If the United States would ever pretend again to be a leader in international law and international human rights, and we require the legal authority to do that. And the international legal system and the international human rights system doesn't work, at least from the standpoint of the United States. If we say that human rights principles and international law prohibiting torture are for others, but they don't apply to us, that we will not hold ourselves to the same standard that we would hold others to. And that tends to weaken the strength of international law, the strength of international human rights. It tends to diminish the principle of accountability and creates a precedent for other nations to follow. The precedent which the United States has established after the Bush administration and today is that for national security reasons, nations are permitted to violate international law and human rights principles with impunity. And that doesn't make us safer. This is not in conformity with our foreign policy goals and objectives. We don't want to make the world safe for torture. We want to make the world less safe for those who would torture. We want to protect human dignity. And to the extent that we eliminate accountability for this, then we weaken these kinds of principles and weaken the national objective, international objective of enforcing human rights rather than weakening them.
During the Haspel hearings, we heard a lot of senators say, well, torture is illegal now, but it was legal when Ms. Haspel was engaged in activities, say, at Cat's Eye and in Thailand and so on. Is that correct?
No, it's not correct. Torture was illegal then, it was illegal before 9/11, and it continues to be illegal today. The principle is not really different. We just chose not to enforce it. And actually, what the Bush administration did was sought to redefine the law or to simply ignore it, to pretend to give legal analysis, to pretend that, in fact, the activities were legal, but the reality is not that at all. So that's the problem.
When you say illegal, you don't just mean international law, which...
Domestic law.
You also mean domestic law.
And by the way, the test is not whether an attorney in the administration might have said it was legal or not. The only test is the actual impact on the victim. So we don't care what the Cambodian lawyers or the Nazi lawyers may have said about torturing those kinds of countries. The only standard of measurement is the actual degree of pain inflicted on the individual as registered by that individual.
Steve, you want to jump?
Yeah, I do about the accountability, because there's the other aspect of it. In terms of the corrosive, when you don't have accountability at the highest level, it is very corrosive to the institution of the Army, Navy, Air Force. Right? We are bred duty, honor, country. We're bred that we're responsible. We go out on a mission, or we're in a cockpit, or wherever we are, we're responsible to do our duty and to fulfill those responsibilities. And when we see our senior officers or other officials get promoted, not held accountability, that's the wrong lesson to give to that young officer or NCO on the front lines when you're expecting them to do the right thing. Because what you're teaching them is you can do what you can get away with.
And indeed, if you receive an illegal order, it's not just permissible for you to report it up the chain and refuse to follow it, it's mandatory, I take it. So you put individuals receiving those orders in a conflicted position.
And I hate to say it, I mean, a lot of the career path was don't ever get yourself in a position that's going to be compromising, and then get promoted. It's very corrosive.
And to put this in a domestic context, what signal does the pardon of Joe Arpaio send to domestic law enforcement officers? This is an individual who was convicted but not sentenced of systematically brutalizing hundreds of individuals. So the president, by partnering him, says, no, this is tolerable. What's the message that we if we don't hold anybody accountable for the deliberate separation of children from families at the border. That program, it would appear, was meant to send a signal to try to terrorize individuals who might think of seeking asylum in this country with the penalty of being separated indefinitely from their own children. It's the deliberate use of brutality to achieve some policy objectives or national objectives, which is an indication of how I think the torture policies contributed to this. But it just shows how if you inject brutality or tolerance for brutality at any level in your governance structure, it can metastasize in other areas as well.
Let's talk about different methods of accountability. Quite controversially, some people have claimed following widespread instances of government-authored brutality that there should not be prosecutions, there should be something like a Truth and Reconciliation Commission, such as occurred after the fall of apartheid in South Africa. After the brutalities in the former Yugoslavia, there was eventually a tribunal commissioned. Rwanda. Do we need prosecution to vindicate the rule of law, or is it enough to try to get transparency, awareness, knowledge, and maybe some admissions by government or former government officials?
Well, as a matter of international law, yes, we do need prosecutions because the standard is investigate, prosecute, and punish. It doesn't say for how long, it doesn't say what level of punishment, but it does say punish. It doesn't say tell the truth only. So I also think, transitional justice mechanisms are very useful, but they're not useful when they deliberately exclude the judicial investigation of crimes. If they are, restricted to only those bearing the highest responsibility, that's acceptable. Although, obedience to orders is not a legal defense in these kinds of crimes. But if they are supplemented by a truth-telling exercise and by reparations to the victims and by efforts at institutional reform to prevent recurrence of these things, that's what we call transitional justice. But it's not supposed to substitute for the obligation to investigate and prosecute and punish at least the most serious crimes and those bearing the highest responsibility for them. The idea is, of course, that torture, but not only torture, disappearances, extrajudicial executions, war crimes are of such entity that that a state cannot choose to investigate and prosecute them. It has to investigate and prosecute them. Of course, with all the norms of due process and fair trial guarantees that have to be in place. You don't prosecute for the sake of scapegoating, but to demonstrate that the law applies to everybody, and if someone who commits a felony in common crime, inexorably sees the interior of a prison, there is really something odious about the fact that if you did it wearing a uniform or because you were very powerful and you held a position of trust that the society has given you, then you don't have to pay any kind of cost for it. That's why transitional justice helps, because when you have a legacy of very, very serious human rights abuses, it's difficult to expect that we will investigate and prosecute everybody and everything. But even in those cases, at least an effort to set the rule of law in motion and to obtain prosecutions and trials and eventual punishment is central to any transitional justice mechanism as well. I wanted to say also that the premise of the torture memos was not that these techniques were legal. It was a premise as, are you going to get away without being prosecuted for this? And then they turned to the euphemism that this is enhanced interrogation techniques and therefore they're not torture. Therefore, because our laws do demand prosecution for torture, but don't demand prosecution for cruel, inhuman, and degrading treatment, then yeah, you can get away with it. the memos conveniently didn't say that they were still illegal, that they were still prohibited, not only in international law, but in domestic law as well. And so those memos that, any law student that reads them carefully will say, well, this is wrong on the law, and they were withdrawn even by, retired by the Bush administration when they were, when they were leaked to public opinion because it was so embarrassing. Just to think that they are the basis for saying, well, we're not going to prosecute anybody because everybody that we might prosecute would be under the presumption that maybe they thought that they were doing something legal. It's so disingenuous that it's almost laughable if it weren't so tragic.
Obama did make the decision to say that anyone who followed the memos should be immune to prosecution. Steve, in your view, was that the right thing to do? And would there have been a kind of collective psychological benefit for him to take a different course? He could have taken a different course in a number of ways. He could have said that, taken that position, but called for a fleshing out of the facts. What do you think the sort of collective psychology or the impact on the collective psychology was by taking that stance?
The impact of the collective psychology is that you're going to protect it if you are loyal to me. And I think it set up an insidious ethic or sentiment that loyalty is, not to pun intended too much, trumps what you think is a duty, honor, responsibilities that you have. And I think that that really was undermines what we want to see as military professionals. I think it was the wrong thing, frankly.
So two more brief topics, then we'll let members of the audience in. Talking about different methods of accountability, the International Criminal Court has announced that they will look into the possibility of conducting international prosecutions for those responsible for the torture program in Afghanistan in particular. What are the chances that these prosecutions will actually occur, Juan, and what would be the enforcement mechanism for any judgment that in fact would come out of such processes?
Yeah, I am not privy to the evidence that the Office of the Prosecutor might have, so I don't know who will be, investigated, what incidents will be investigated. I just have no information on that. But I do think that as a matter of law, the Office of the Prosecutor, and now, ratified by the pretrial chamber that has allowed that investigation to go forward, is correct. Afghanistan is a party to the Rome Statute, and crimes that are committed in its territory after the entry into force of the Rome Statute are subject to the jurisdiction of the ICC, even if not committed by Afghani citizens, but by others. I don't think there's really a debate about that, and all the threats to, prosecute and freeze the assets of people working on it and all that doesn't change the letter of the law of the Rome Statute, nor the acceptance by Afghanistan of the jurisdiction of the ICC. Now, what will happen first, without knowing who might be prosecuted, is difficult to know. But if individuals are, it's not indicted, but subject to an arrest warrant, and there will be, phases and processes by which not only Afghanistan, but also the United States can challenge those decisions. But if in the end, arrest warrants against American citizens are issued, then they have to appear in The Hague or risk apprehension through Interpol wherever they travel. Now,
So what would happen then? So let's assume that a lot of the defendants would be American, right? So first of all, Alberto, does the ICC have jurisdiction over U.S. defendants?
Well, that's precisely an issue. And in this kind of case, as Juan said, the principle that ICC is claiming to investigate American actions on Afghan soil and also Lithuania, Romania, and Poland is that there was a connection with territorial illegalities committed on the territory of these 4 countries that are members of the ICC. The United States, though, of course, is not a party to the ICC. And the counter argument the United States would be advancing it, we deliberately sought not to become parties to the convention. You can't hold us as a matter of international law liable for violations of an agreement entered into. So that would be one of the principal legal points of conflict between the United States and the ICC.
Right, so the argument will be there's no jurisdiction over American defendants. How does this get resolved in the ICC, and who has the authority to resolve this kind of jurisdictional
The ultimate
debate?
authority is the ICC itself. But it will be aired, it will be debated, and the United States government will have a chance to persuade the ICC that it doesn't have jurisdiction. Unfortunately, it's not going to happen until we see an investigation and a petition to the pretrial chamber, a decision by the pretrial chamber to pursue a case against citizens so and so of the United States, and whether they appear or not and then after that. If there is a warrant of arrest, unfortunately, we can't be very sanguine about that it's going to be implemented, because the ICC has a warrant of arrest against the president of Sudan, al-Bashir, for years now, and he makes a mockery of it by traveling through different countries. If you're asking me, is there a chance that any U.S. citizen will actually be ever prosecuted and tried by the ICC? At this point, I think it's difficult to predict, but things change, and governments change, and support for the ICC may improve over the years. And I think it's important for the ICC to live up to its rules and to follow the evidence wherever it takes it. But obviously the evidence, it's not just a matter of, hey, I want to prosecute an American. The public has to be persuaded that the ICC has the goods, and then the argument for its jurisdiction will have a little more color if we have a really good discussion, an honest discussion about whether or not they have jurisdiction. We're not, I don't know too much public opinion challenging the ICC for exercising jurisdiction against Myanmar by potential defendants for things that are happening in Bangladesh that is also a party to the ICC. I don't know about you, but I think if this is the best chance that we have for accountability for what has happened to the Rohingya, so be it. We should encourage it to happen.
So last question before I invite everyone else in. Torture is now illegal in this country because of the McCain-Feinstein Amendment. Could that amendment importantly links the standards for the treatment of detainees to the Army Field Manual, and says that whatever the Army Field Manual sets as the standards for the treatment of detainees and interrogations is what has to be the case. The Army Field Manual, however, is subject to change upon consultation with the heads of the armed forces by the president. Alberto, do you think that it's likely that, assuming that President Trump stays in office for at least another 2 years, we might actually see a change in the Army Field Manual in order to bring torture back?
I think as long as General Mattis is Secretary of Defense, that's not going to happen. General Mattis has a consistent record of opposing.
Your mic may be coming in and out.
Has a consistent record of opposing torture in the military and outside the military. And as long as he's Secretary of Defense, that's not going to happen. If he's not there, that's a different kind of question. I think there are more barriers to the U.S. utilization of torture, meaning that I think there's greater sensitivity as to the costs associated with this. There won't be the opportunity to deploy the disingenuous or false legal arguments that were deployed during the Bush administration, and there's more sensitivity within the government as to both the illegality and the cost to the nation and personally if one embarks in this path again. Having said that, Trump is clearly a supporter of torture. There are many individuals in his administration that, until they went through confirmation for the positions, were supporters of enhanced interrogation. There seems to be a lot of support within the Republican Party for this still. Every candidate for president on the Republican side, with the exception of Lindsey Graham, supported torture last time around, as an indication of how deeply buried the support for this has been in the national security context. If the United States were to go back to torture, it probably would be through some sort of rendition mechanism that would be easier to conceal and harder to track down by the American public.
Steve, why do you think there is such appeal in the American population to this message? Well, we want to bring back torture, and moreover, you know, the appeal of this message exists without really having anyone to torture, right? So the idea of bringing back torture without having any obvious suspect on whom to inflict this torture is a sort of puzzling feature of this dialogue. Where's this?
Well, I don't think it's puzzling because it's so common that candidates or political figures, leaders, play on fear. And you get an instinctual reaction. And so that people, once it's evoked, once the feeling like I'm not safe or something around me is not safe, they're, you know, the reflex is I'm going to do what I got to do to protect myself. And I think that's human nature. And the protracted and the thoughtful debate and sense of being able to discuss what the implications are. You know, it is the typical, you know, thinking fast, thinking slow that Professor Kahneman got his Nobel Prize for. You know, the thinking fast reflex is, oh, I got to do this now, I'm going to protect myself. And then you somehow want to be able to get people in a modality to say, well, wait a minute, would you really do that at that moment? Is that what you need to do? And that's very hard. And I'm not sure, I'm not a, you know, political scientist, but I don't think our country is there right now. I don't think
there's
the
a huge
dialogue.
rise in xenophobia, anti-Muslim sentiment, and fear of even Mexicans, right? The appeal of build the wall, keep them out. Is this partly one of the legacies of the U.S. torture program?
Well, no, I think it's one of the net legacies of 9/11.
Okay.
And I've felt from the beginning that the president at that time failed to exercise what would have been by far the best protection and safeguard, which is to say to Americans, this is terrible, this is heinous, but you don't need to worry. We're going to take care of this. This is not Pearl Harbor. And to calm everyone's emotions and to say, we're going to recover, but we're going to move on. But in fact, what happened was immediately there was an exploitation of fear. And that persisted, and it came out in the torture program, and who knows, maybe it came out when we had the big recession crash of '08, and people were worrying about, you know, day to day about their lives. So I think it's, in my view, it's a legacy of 9/11 and the shock that followed that.
All right, well, I think we have some microphones going around, and we have a very distinguished audience here today, authors from the forthcoming volume that I mentioned, and no doubt others. Please identify yourself, if you don't mind, when you ask a question and or make a comment, and we'll get our panelists talking with you. Jens, you want to start out?
Hi, Professor Oline, Cornell Law School. I wanted to ask briefly about punishment for torture, which is something that Professor Méndez brought up, and the sort of essential place that punishment has in the overall legal obligations here, investigation, prosecution, and punishment, and how strictly we should construe the punishment requirement. Because when you think about the requirement to punish, it is a little bit of an uncomfortable fit with the way human rights activists and lawyers often think about punishment and statehood. They often think that the state is permitted to punish, but they rarely think of a state having a legal obligation to punish. And what it means when sort of taken to its logical culmination is that really in some situations excessive mercy is not permitted. That if the state wants to say we're going to exercise some mercy and decide not to punish someone, that's just not an option for a state to do. And when you think, for example, that there might be a point at which a punishment is so low that we might say that there's been no significant punishment at all. For example, if a state says there's not going to be we're going to suspend the sentence, or we're going to issue a small token monetary fine, or someone will be in prison for 30 days for an act of torture. The requirement for punishment for torture seems to suggest that that's legally problematic. And I was wondering if you could just talk a little bit about how that fits in with a sort of general, within the general structure of a theory of punishment under international law.
Well, first, international law does not prohibit clemency or even amnesty under some circumstances. And I'm glad for the question, because I may have stated my position on that too broadly. For example, the crime of rebellion and sedition to put an end to an internal war is not only permissible, it's almost required by Protocol 2 of the Geneva Conventions, but it applies to the crime of rebellion or sedition, that is, to the crime of rising up in arms against a state. It doesn't apply to war crimes committed in the course of that same civil war or whatever. But I do think that there's a category of human rights violations that are also a category of very serious crimes that from Nuremberg on requires punishment, let me rephrase, requires investigation, prosecution, and punishment where appropriate. And those are the crimes that we call international crimes: genocide, crimes against humanity, war crimes, torture, disappearances, where the latter two, even an isolated event, without it being a crime, a part of a widespread or systematic attack on the civilian population, which would make it a crime against humanity, still elicit from the state an obligation to investigate, prosecute, and punish. Now, the problem is how and whether, how you do it. And what I was trying to say earlier was that the state cannot, any state, cannot escape the responsibility for investigating those kinds of crimes, not lower level offenses that of course can always be a subject of clemency in different forms, pardons, amnesties, etc. But for those kinds of crimes, there's an investigation to investigate them, to tell the truth to the society, and to investigate those bearing responsibility for them, and to punish them. After punishment, there can be clemency. There can be, pardons for humanitarian reasons, etc. As long as it's not a mockery of the idea itself. As long as it doesn't result in a slap on the wrist for, say, murdering a family, for example. So, in other words, the obligation to investigate, prosecute, and punish is international law. It's binding international law because it's treaty law, obviously binding on those states that have signed and ratified these conventions. But when it comes to genocide, crimes against humanity, and war crimes, it's also customary international law. So what do you do when you have a legacy of many, many, many cases? Well, yes, then you prioritize, you strategize, etc. But the priorities and strategies may leave a lot of cases out. There's no question, and a lot of very culpable people out as well. But at least it has to make sense to the society and to the population that this is not either scapegoating or tokenism, that it is a good faith effort at living up to this fundamental human rights obligation.
I think we had a gentleman here who had his hand up before. And if you can, we can tee up on this side. If someone wants to ask the next question, please raise your hand so we don't have...
Yes, I'm Alan Foreman. I'm a graduate of the law school. Assume I was taken prisoner by the American soldiers in Afghanistan, and my interrogators tortured me. And I want to challenge that. How would I do that? And would I be doing it under US law or Afghani law or under international law?
Let me take a crack. First, all of those jurisdictions have jurisdiction. In other words, Afghani judges might, take the case, but also the United States, because the perpetrator presumably is a U.S. citizen. They have what is called active personality jurisdiction, and they have an obligation to investigate it. So it could be done by U.S. Courts as well. And in the case of international jurisdictions, it depends on what territory and which conventions or treaties apply there, and whether there's an organ that has jurisdiction. Again, in the case of Afghanistan, yes, the ICC has jurisdiction, but in other countries, the ICC doesn't have jurisdiction, and you're left with the possibility of just having non-judicial kind of investigations, like through special rapporteurships, or if it happens in Europe, the European Court of Human Rights. As you probably know, there's already been 3 or 4 decisions by the European Court of Human Rights against Romania, Poland, and Macedonia, dealing with extraordinary renditions, and specifically mentioned the CIA and US involvement in it. But of course, the European Court of Human Rights doesn't have jurisdiction over the United States. So that there's so many variables to it that it's difficult to say across the board, who would have jurisdiction without knowing exactly which case we're talking about.
I mean, as an American citizen, you could brought a claim in American courts, a lawsuit alleging violation of the anti-torture criminal statutes and constitutional rights.
So I have to get a lawyer.
Oh, yes.
Always good to get a lawyer.
Get a lawyer. Hi, thank you for, this has been a great couple hours with you all. My name is John Muffler. I'm currently on the faculty of the National Judicial College and the National Council of Juvenile and Family Court Judges. I'm a retired U.S. Marshal also. My question to the panel, and maybe for the gentleman to my right here, is about how do you, changing the narrative, right? So we made this, what I appreciated about this conversation was it wasn't just, torturing someone in a foreign country. You brought it to the local level. Law enforcement today, across the country, coercing and getting testimony, wherever it may be, whether it's in the U.S. or Argentina, in your case. So how do we change that narrative? And are you aware of police departments or perhaps military that are putting it in their curriculum to change that? Because you get the tough guys who teach these classes, and the students learn how to be a tough guy, and that's how you go about business. So are you aware of that attempt to change the narrative at all, and who's doing that? What are the successes? I don't know if that Mark might know that one, I don't know.
Alberto, do you want to take that?
I'm not sure I understood the question. Narrative
Changing the
about
narrative,
brutality?
changing the narrative at least the local level within law enforcement. Are you aware of attempts to change that in curriculums in investigative techniques within local law enforcement?
It's really not my field. Not my field, so I'm not going to hazard a guess about what the
I mean, the project of drafting an instrument in international law that would be soft law, non-binding, if you will, but could be very authoritative, is an attempt at changing the narrative.
Right.
And if we have enough support, not only from academics, which is a lot easier to get, but also from practitioners and particularly investigators around the world, I think we can get a very good document that will help change the narrative. We won't automatically change it. But just to, when we talk about a soft law instrument, it doesn't mean just because it's non-binding that nobody will care. There are a couple of examples, like standard minimum rules for the treatment of prisoners, the Istanbul Protocol for the detection of torture, that have achieved that kind of weight and credibility because of their text, not because they are binding or non-binding. So that's what we're hoping for, and I think, at least I'm very encouraged that we have a lot of support for.
And certainly, one can also say that efforts in this country relating to community policing and other experimental training protocols that have been put in place have shown a lot of success. And we know some of the abysmal failures around policing as well. So this is, of course, much more in the Quattrone Center's domain that has enormous expertise in this area. But I think those are all attempts to change the narrative. Jay, I think, was next, and then Mark.
Thanks. So just before I even ask my question, just the obvious reminder that 90% of all policemen in London do not carry a gun. Over a 10-year period, 3,000 incidents where guns were brought to a scene, not one shot was fired. So there are different mechanisms of policing in different cultures. And that's one way to benchmark where we want to go, I think. Okay. My question is really about the impunity problem. And it seems to me that there are three cultural markers that make impunity part of our currency. So the first seems to me, the Obama issue is one of the overriding reasons I think there were no prosecutions is because he thought it would be viewed as politics and not law. So the question is, new administrations have a hard time claiming that previous administrations did illegal things without making it political. The second issue of impunity is, it seems to me, we view state actors, including policemen, differently than we include private actors. And we do so, I think, for a good reason. Namely, private actors, when they do wrong, are acting out of self-interest. We typically view state actors, when they do wrong, at least trying to act out of the collective interest, even if they misjudge it. And I think we are puzzled about what is involved in that difference between acting out of a collective interest and a self-interest. The third problem, which it seems to me we touched on at the very end, is the relationship between municipal law and international law. We still do not have a settled view anywhere about how this relationship is meant to work, right? That the best we come up with is that international laws are recommendations that get their force by being made municipal law, but we still don't have a powerful enough international law to make what I think Juan wants in the case of investigate, prosecute, punish for clear cases of non-derogable, right, laws effective. And that's a cultural issue, and it seems to me we're going backwards. That is, it seems that we're moving to the national away from the international at the moment.
Yeah. So, sort of, we don't have time to answer it great length, and we have one more question I want to get in, but I think your question is really about the choice of frameworks as well as the relationship between local and international law, in effect. And of course, we've seen that in the difficulty categorizing unlawful combatants, whether or not we should think of them as in a law enforcement framework or think of them in a military framework. Does anybody want to respond to some of those thoughts?
I think the political element is also paramount now. I mean, as much as it's legally unthinkable that there wouldn't be accountability for the crime of torture, by the same token, it's equally politically unthinkable that there would be accountability given the situation. Yeah. I mean, when the ICC launches its Afghan investigation, which will embrace the American investigation, I think you're probably going to find a unanimous Congress, both parties, every individual opposing any participation, providing no support for that. And I think you'll find 99% of the American public also opposing that kind of accountability. So I think, for those of us who think that accountability is important for a variety of reasons, as we've discussed, the issue is not between accountability, as Juan outlined it under the black letter law, and no accountability. It's no accountability and something better than no accountability, but still far from the end of the spectrum. So this is the dilemma, the real life political dilemma that we find ourselves in. How do we achieve some kind of accountability? Just one word on this. I think former Justice Stevens addressed the issue kind of obliquely. He was talking about Guantanamo, but really he was talking about torture. And the model he was suggesting was something like what the United States did in response to the Japanese-American internments. So there was no prosecution for the knowing violation of their constitutional rights, but 50 years after the fact, you had an American president acknowledge that a wrong was committed, assume national responsibility for this, then provide some restitution to the survivors at that point. And something like that has appealed to me as one way for the United States, in combination with other measures, to at least achieve some accountability and create a kind of like inflection point for going forward, which would help ensure that the United States would not commit torture again in the future.
And let me give the last question to Mark Fallon.
Yeah, did you want me to answer John's question on the cultural adaptation?
Up to you. We have just a couple minutes to wrap.
John, it's difficult right now. As a retired Fed, I'm currently on the International Association of Chiefs of Police, in what's called the Impact Section, International Managers of Police Academies and College Training. And we're trying to expedite the cultural acceptance of behavioral sciences in the same manner that we've accepted the physical sciences. We've adapted our crime scene training to DNA. We've accepted the physical sciences, but the warm and fuzzy behavioral sciences, there are some pockets. There's been some successes at the Federal Law Enforcement Training Center, LAPD, Dallas PD, Rhode Island Chiefs, a few pockets, but trying to get that community to accept things that aren't painted black and called tactical is harder without examples and without credibility, and part of that effort. And so for my section of ICP is a 30,000 member international police association, mostly leadership positions, and the section I chair has international managers of police academies and college training. And so in October, our conference is in Orlando, and for my section meeting, I've asked Juan to be the keynote speaker to again try to explain what we're trying to do. I'm a member of the steering committee, and I'm very fortunate because the vice chair is the director of strategy for the UN police, who is looking to adapt these standards for the police. So what I'm hoping for is small pockets of success to utilize as examples so that others might emulate those. But it's hard without those credible examples, but we're working on it, and we will get there.
Thank you so much, Mark. And with great thanks to our panelists and to Professor Méndez for his fascinating work and talk, please join me in thanking her.